Hi everybody, this is Michael Blake again of the law offices of Michael A. Blake. I am a patent and trademark attorney in Milford, Connecticut. And today I would like to talk about what attorneys should know about intellectual property. I am an intellectual property attorney. I do patents, trademarks, and copyrights. But many attorneys don't know much about IP. They may be doing things like personal injury, family law, wills and trusts, real estate, but intellectual property might be a topic that they're not very comfortable with. So I just want to give a little talk about it today. So intellectual property covers a bunch of different types of ways to protect your invention, your idea, your works. And so I just want to give a quick discussion of what types of protections there are under the intellectual property umbrella. So the first one, and probably the most well-known, is patents. And patents protect inventions. In order to prepare and file a patent, one has to be a patent attorney or a patent agent registered with the USPTO. Of course, an inventor can prepare and file his or her own patent application and file it. But if an attorney wants to prepare and file a patent application, he or she has to be registered before the USPTO and take a special patent bar exam, which I have and passed. The next type of intellectual property are trademarks. And trademarks protect brand names, logos. Trademarks are brand identifiers. They identify the originator of a good or service. Any type of an attorney can file a trademark application on behalf of his or her client. There's no special bar exam for that, but it can get tricky, and unless you know what you're doing, you could mess it up pretty easily. The next type of intellectual property I want to talk about is copyrights. Copyrights protect creative works. So things like screenplays, movies, photographs, drawings, sculptures, architectural works. Those things are protected by copyright. And one thing to note about copyright is as soon as you create the work, the creative work, in some sort of tangible medium, which also includes computer memory, you have an automatic copyright in that work. It's not registered yet, but you do have automatic copyright in that work. When you register a copyright, that gives you some additional rights, like you can't sue anybody for copyright infringement until you register the work. The next type of intellectual property is trade secrets. And trade secrets can protect just about anything. And the idea behind trade secrets is you got to keep it secret. So a trade secret could be customer lists, ways of doing business. It could be an invention, could be a recipe like the Coca-Cola recipe or the Kentucky Fried Chicken recipe. And trade secrets are good, especially for things that are not otherwise protectable by patent, for instance. So recipes are very difficult to protect by patents because food has been around for so long, for as long as humans have been around, that it's probably impossible to get a recipe patented nowadays, because probably somebody in the past had created something similar to your recipe that you want to protect. But you can protect it with trade secrets by making sure only very few people know about your trade secret recipe in your company, and you take steps to limit access to that trade secret. And of course, it doesn't have to be recipes. Like I said, it could be customer list, ways of doing business, manuals, business manuals, all sorts of things. All right. The next type of way to protect an intellectual property, and it's not a type of intellectual property, but the way to protect it are non-disclosure agreements or confidentiality agreements. So if you're going to disclose something or talk about something with somebody, but you want to make sure that person keeps it secret, you probably want to have him or her sign a non-disclosure or confidentiality agreement, which is an agreement where the parties sign the agreement and they agree to keep secret whatever is discussed during a meeting or a series of meetings or during some sort of work time period. And that's a good catch-all for people. Like, for instance, if you want to talk about an invention with someone, but you haven't filed a patent application yet, it would be a very good idea to get that person to sign a non-disclosure agreement where they promise to keep secret whatever you discuss with respect to that invention. And if you find out later that they disclosed that invention to somebody, then you can sue them for breach of contract. You wouldn't be able to sue them for a patent infringement necessarily because you probably haven't filed a patent application yet. But you certainly can sue them in state court for breach of contract. And the last thing I want to say is, if you're worried about your intellectual property or your client's intellectual property, a real good rule of thumb is just keep it secret. Don't tell anyone about that thing that you want to keep secret until you talk to an intellectual property attorney to figure out how to protect it. Well, that's the end of that talk. And if you want to contact me, I am Michael Blake, and my website is blake-ip.com. And I'm in Milford, Connecticut. Thank you.